New York's assault laws, called battery in other states, range from misdemeanors to felonies. Least seriously, assault in the third degree is defined as intentionally or recklessly causing a physical injury to a person. Physical injury means impairment of physical condition or substantial pain. That's extremely broad. It does not have to be a wound gushing blood. The crime is a Class A misdemeanor and punished by up to 1 year in jail, 60 days jail, and 2 to 3 years probation, straight probation of 2 to 3 years, or simply a conditional discharge. Harassment in the second degree is usually also charged with assault in the third degree. Harassment only requires physical contact, like a slap, kick, or punch, but not a physical injury. If you are charged with assault in the third degree and do not have a criminal record and the injury is not severe, it is possible that a prosecutor will offer a non-criminal plea bargain. Most often that means an ACD, which is dismissed and sealed in 6 months or 1 year, or harassment or disorderly conduct, both of which are violations and not crimes, and are ultimately sealed, unless a plea to harassment involves domestic violence. Felony assault includes dozens of crimes, assault in the first or second degree, which are most common, vehicular assault, gang assault, injuring a train conductor or bus driver, to name just a few. Assault in the second degree is defined as intentionally causing either a serious physical injury or a physical injury with a weapon. Serious physical injury means a substantial risk of death or impairment of health or bodily organ function. Weapons include the obvious, knives and guns, the less obvious, a frying pan or broom, and even a wall or the sidewalk. The crime is a Class D violent felony and may be punished by 2 to 7 years prison and post-release supervision, 1 year jail, or a combination of up to 6 months jail and 5 years probation. Assault in the first degree is defined as intentionally causing a serious physical injury with a weapon by engaging in reckless behavior that results in grave risk of death, or causing a serious physical injury while committing or attempting to commit a felony. The crime is a Class B violent felony and may be punished by 5 to 25 years prison and post-release supervision. For a first-time arrest, a felony assault charge does not automatically mean the prosecutor will not offer a plea bargain to a lesser crime. The possible outcome depends on the facts, the nature of the injury, and prior convictions or arrest. One way to fight an assault charge is by arguing self-defense. Generally, you may defend yourself if you need to fend off an attack. The law in self-defense is complicated and has exceptions, including if you claim self-defense but you were the initial aggressor. And you may not use deadly physical force unless it is being used on you, and you cannot retreat safely unless in your own home. The best way to determine the possible outcome of an assault charge of any degree is to contact me to discuss the case fully.